citation of JS Sri Lanka against the Secretary of State for the Home Department.
The judgment of the court will be given by Lord Brown.
The respondent is a Sri Lankan Tamil. In 1992, at the age of 10, he became a member of the LTTE the following year, joining their intelligence division. He occupied various positions of responsibility and gained promotions within the organisation. In December 2006, he learned the Sri Lankan government had discovered his presence in Colombo and membership of the LTTE. In February 2007, he arrived in the UK and applied for asylum. The respondent's application for asylum was refused by the Secretary of State solely by reference to Article 1FA of the Refugee Convention, which states that a person is not to be recognised as a refugee where, quote, there are serious reasons for considering that A, he has committed a crime against peace, a war crime, or a crime against humanity as defined in the international instruments drawn up to make provision in respect of such crimes. The respondent sought judicial review of the Secretary of State's decision. The Court of Appeal quashed the Secretary of State's decision. The Secretary of State appealed. The Supreme Court unanimously dismisses the appeal, but varies the order made by the Court of Appeal to provide that in redetermining the respondent's asylum application, the Secretary of State should direct himself in accordance with this Court's judgments, not those of the Court of Appeal. The Court on this appeal has essentially three tasks. The first is to decide whether the Court of Appeal was right to quash the refusal decision and remit the case for redetermination by the Secretary of State. Secondly, the Court has to decide on the correctness of the principles laid down in Gurung. The Court's third task is to decide whether the Court of Appeal was right to interpret war crimes liability under Article 1FA as narrowly as they appeared to do, essentially so as to encompass no more than joint enterprise liability. In relation to the first issue, it could not be said of the LTTE that as an organisation it was, quote, predominantly terrorist in character. There was accordingly no question of presuming that the respondent's voluntary membership of this organisation amounted to personal and knowing participation, or at least acquiescence amounting to complicity in the crimes in question. As to the second issue, there are criticisms to be made of Gurung, and it should not in future be accorded the same standing as it seems hitherto to have enjoyed. It is unhelpful to attempt to carve out from amongst organisations engaging in terrorism a subcategory of those, quote, whose aims, methods and activities are predominantly terrorist in character, unquote, and to suggest that membership of one of these gives rise to the presumption of criminal complicity. Another criticism to be made of Gurung is its introduction of the idea of a continuum in relation to the types of organisations and their political aims and objectives for war crimes cases. War crimes are war crimes, however benevolent and estimable may be the long-term aims of those concerned. As to the third issue, the Court of Appeal took too narrow an approach, appearing to confine Article 1F liability essentially to just the same sort of joint criminal enterprises as would result in convictions under domestic law. An accused is disqualified under Article 1FA if there are serious reasons for considering him voluntarily to have contributed in a significant way to the organisation's ability to pursue its purpose of committing war crimes, aware that his assistance will in fact further that purpose.
The Court will now adjourn.